This is TWiT.
A case before the Supreme Court has the potential to change the protections that tech companies currently enjoy when storing its user data on servers outside of the U.S. Joining us to dive into the details of the United States versus Microsoft Corporation case is Selena Larson from CNN Tech. Welcome, Selena.
Hi, guys. How's it going?
It's going great. It's great to get you back. So let's go back to 2013 to kind of set the stage a little bit. Microsoft was issued a warrant that would involve giving up its data held in Ireland. Tell us a little bit about the germination of the case that we're seeing now.
So we don't know the specifics regarding the case, but they were served with a warrant back in 2013 for emails and information associated with an account related to a criminal drug trafficking investigation. Some of the information was stored locally in the U.S., and that information they would provide, but some of their information was stored in Ireland, and they're like, sorry, your warrant does not extend to data stored overseas. So they refused to release that information. It went up to the courts. A lower court judge approved the warrant, but they took it to the U.S. Court of Appeals for the Second Circuit, and they rejected the warrant in favor of Microsoft. So, now it's up to the Supreme Court to decide this case and figure out whether that warrant applies to data stored overseas.
So what is Microsoft actually saying that the problem is with accessing these emails stored overseas?
So essentially they're arguing, well, first of all, that they're arguing that this isn't an issue for the courts to decide, but it should be Congress, because effectively the DOJ is arguing that the Stored Communications Act, which was written in 1986, which basically establishes the relationships between law enforcement and tech companies that deal with the data, that says that this is outdated. And so what they're calling on doesn't really cover cloud computing. And they say, this is a case, the Stored Communications Act of 1986 doesn't apply to this particular case. It's, something that needs to be updated and move forward. Essentially, they say, and privacy advocates say this too, that if, we could just go and get data from overseas, and another country could say, oh, well, I can, get data stored in the U.S. And so that's kind of the argument there.
Obviously, in 1986, the world is a lot different, now versus 86. What exactly about the Stored Communications Act in 1986 differs? Like, what is the big reason that it applied then, but it doesn't apply now? I'm kind of confused about that.
So that law tried to establish a type of privacy that users can expect from their ISPs. And essentially it says, tech companies, ISPs can't just turn over data to the law enforcement willy-nilly. It's essentially the Fourth Amendment protections that prohibit search and seizure, to your house, your apartment or whatever, but applied to the internet. Currently we have fewer Fourth Amendment protections than your physical location, like your house. But back then when it was written, obviously, data was stored in servers locally. It was stored on your computer. We didn't have these massive corporations storing vast amounts of data all over the world. Tech companies, Microsoft is arguing that this act should be, updated, or the law should be updated to sort of figure out how laws apply when the information the U.S. wants is stored in foreign countries.
And Microsoft is also saying that this poses a risk to us in the United States. Can you talk a little bit about that?
Yeah. So what's interesting actually is this argument was they blogged about it a lot. And, a few amicus briefs were filed from foreign countries that were like, hey, this could, impact a lot of different people's privacy. This could affect Europeans' privacy, Americans' privacy. Essentially, it would be sort of like a tit for tat potential, right? Where if they say that the U.S., I can just go grab this data, then another country would say, well, we can grab your data too. Interestingly, though, that argument did not really come up all that much during arguments on Tuesday. It was more, they were focusing less on the privacy issue or the potential for affecting Americans' privacy, and more on the fact that this is something that Congress should decide. This is up to the laws. This isn't, it's outdated laws. If we do implement better protections and write this out a little bit more, because if there were laws, like currently the Cloud Act has been proposed by some folks in Congress that could effectively render this case totally moot. by updating laws to sort of fit the current digital landscape.
And talking a little bit about the tit for tat potential that you're talking about there. I mean, talk a little bit about like what other governments could actually do in that regard. Like I've read a little bit about, there are certain governments that you probably wouldn't want to have that ability, that access to, or that, I don't know, that leverage, let's say, over, in response to this. Talk a little bit about that.
Yeah, so what's kind of interesting is obviously, as you guys have probably talked about, a lot of the European privacy laws are a lot stricter than here in the U.S. and even more strict than a lot of places abroad, right? So one of the things that was pretty interesting that I've been talking to a couple experts about is if this, if they said unilaterally that the U.S. can just kind of go and take data from these companies or from, data stored overseas or whatever, because it falls under U.S. regulations, it could potentially open up the possibility for foreign countries to say, oh, okay, well, if these American companies are going to be able to say, oh, we're going to get this data in this foreign country because it's U.S. law, we are going to require these foreign companies to have data stored on our property, like in our country. So then they have to comply to our laws. So it wouldn't be like, oh, U.S. can just do whatever they want willy-nilly. It would be like, oh, well, if you're not going to obey my country's laws, if you're not going to, take my citizens' privacy into consideration, then we're just going to force you to store data locally and abide by our rules. And so that's kind of interesting. It's a possibility that people have been talking about that this might actually come up, and it could sort of create this similar to like what China is doing, right? So right. It's the Great Firewall. It's like China has control over data stored in China. I mean, you just saw with Apple like storing iCloud information in China. So the concern is if there's just this unilateral power for the U.S. to sort of go and do whatever they want, then, these countries would be like, hold on, we have to sort of figure out how we can do this and protect, people in our country.
So privacy is one of those things that doesn't fall down party lines very often. In one of your pieces, you wrote that Rob Joyce, who's the cybersecurity coordinator for the NSC, the National Security Council, he says he agrees with Microsoft and looking to move on the Cloud Act, which you mentioned before. And you said that the Cloud Act would then, if that passed, it would make this whole thing moot. I mean, is the Cloud Act something that privacy advocates would look highly on, or is it something a little sketchy?
So it's actually pretty interesting. The act does have some bipartisan support. And again, it's just been introduced. I believe it was in early February. So it's still in the early stages. It hasn't even been marked up yet. But it is essentially a way for countries to enter these unilateral agreements to be like, oh, if the U.S. has information that they want to get out of Ireland or the U.K. or elsewhere in Europe, then we sort of enter these agreements to say, okay, we can do that. But the agreement can only be struck if countries achieve certain human rights and privacy boundaries, essentially, right? So it's essentially trying to protect the people in these countries and to protect the information. So, if they enter this agreement, they only do so under those standards. However, some privacy activists say that these standards for privacy and human rights are not quite enough. They do. It is an interesting step. Everyone pretty much acknowledges that it's a great step forward. It's a way to improve the law. It's a way to, sort of establish this criteria for our world of the cloud, right? But you do have some concerns over, these issues or these standards not being totally met. So essentially, that does have bipartisan support. Microsoft, Facebook, Apple, Google. All the big companies support the Cloud Act. So it will be interesting to see moving forward. So for instance, in this case, right, it's Microsoft seeking data from Ireland. And theoretically, we would have had an agreement with the country and we wouldn't have gone to court over this. So we would have been like, oh, we have this data agreement because you meet certain privacy and human rights guidelines. Let's exchange data.
Mm-hmm. And then if the Supreme Court ends up ruling in Microsoft's favor, are we to expect new laws around like data localization in response to that? Is that the type of stuff that we'd see in response?
So everybody basically says that no matter what the outcome of this case is, eventually Congress is going to have to act. Congress is going to have to enact new laws. We're going to have to update, 1986, the laws written back then don't really apply anymore. It's really hard. You have these like questions. And so if, regardless of whoever wins in the case, Congress is ultimately going to have to legislate on this. And what's pretty interesting is Ruth Bader Ginsburg actually brought it up. Justice Ginsburg said, why are we doing this when, Congress could potentially act on that? And it does seem like some of the justices were in favor of, having legislation sort this out as opposed to, the Supreme Court having to decide something. But if, they're expected to rule on it by late June, and no matter the outcome, it's likely we'll get legislation. And the outcome will just affect this one case in particular because of the likely forthcoming legislation.
Interesting stuff. Selena Larson, really appreciate you taking the time to talk with us again. It's great to see you. Thank you.
Yeah, always a pleasure. Thanks, guys.
All right, CNN Tech. We'll talk to you soon, Selena.